Is a voice recording enough to prove an oral contract? So imagine you have two parties. They talk about an agreement. They say, hey, I'll give you a simple example. I'll pay you $100 to paint my fence. And the painter says, sure, that sounds great. The painter shows up to paint the fence that morning, and the homeowner says, I changed my mind. I don't want you to do it. That was an oral contract because the owner said, I'll pay you $100 to paint my fence. And the painter said, sure. The owner is technically breaching that contract by trying to back out of it now and saying, hey, I changed my mind. But it was oral. It wasn't in writing. It was spoken, not on paper, not in email. Is a voice recording enough to prove an oral contract? All sorts of evidence can be used to prove that an oral contract exists. You can use paper, email, testimony of someone else, a diary, a journal. There are all sorts of ways to present evidence in court to prove that an oral contract existed. And an oral contract is usually just as enforceable as a written contract. There are a few exceptions to that. It's called the statute of frauds. For example, transactions in real estate need to be in writing under the statute of frauds. For example, if the other side admits that there was a contract in place, even if it was oral, that is usually an exception to the statute of frauds. And there are other exceptions. If you have other questions, put them in the comments below. I'm Aaron Hall, an attorney for business owners and entrepreneurial companies. You can learn more about me at aaronhall.com. And if you'd like to sign up for our free resources, go to aaronhall.com/free.